certainly have fears that there is a serial killer at loose in Perth.
Sarah Spears, Jane Rimmer, Kira Glennon.
And every time you saw a young girl walking by, you think, oh God, is she going to be the next victim?
Now, one man stands accused.
If police are right and Edwards is the Claremont serial killer, he's been hiding in plain sight for 20 years.
Just when the trial of the century was due to enter its final days, another unexpected delay stopped proceedings. Hello and welcome back to Claremont in Conversation. Natalie Bongiolo, Damien Cripps and Tim Clarke with you. So Tim, you're at court this morning, you're there, you're ready to go, and then at the 11th hour a decision is made and you're not going to court.
Yeah, that's right, Nat. I had a fresh notepad ready to go, my pencils were sharpened, and then, unfortunately we were informed that there would be a little bit of a delay, which hadn't been flagged at all until we actually arrived at court. The reasons for that delay are a little bit vague at the moment. The official line from the WA Supreme Court, it was a public health concern, which sounds quite dramatic. I had been led to understand that it might have been some mild sickness that prosecutor Carmel Barbagallo had come down with over the last 24 to 48 hours, but the court has since told me that might not be correct, so we're still a little bit in the dark. But what we do know, obviously, is that we didn't go ahead today, and as it stands right now, we should be going ahead tomorrow, so we'll wait and see.
And was Bradley Edwards brought to court this morning?
Well, that was my understanding, that the van had brought him up from Casuarina prison. But again, I'm not entirely clear on that because I didn't see the van with my own eyes. But that was my understanding. As we've described before, to get to court for a 10 o'clock start, you do have to leave significantly earlier than that. To go through all the security checks that obviously have to be done, checking someone out of a high security prison and then checking them into court. But again, what I do know for sure, because I did see this with my own eyes, was that his parents were there and fully expecting proceedings to start on time. But theirs was a wasted trip, as was mine, and as was a lot of people that did turn up at court expecting to see it all start today. So, yeah, as I say, fingers crossed. It's only a short delay and it's not a significant health concern from one of the major parties, and we'll get underway tomorrow, being Tuesday.
I mean, I guess given the COVID situation, you can understand that there would be a high degree of caution around anyone who's feeling unwell. But I guess apart from that, Damien, a key player, whether it be the prosecutor or the defence, is it really important that they are feeling at their best?
Nat, I think it's imperative. I think that if you because you're only going to have your own, you're going to have to answer to yourself later on if you've missed something. You've got the opportunity. You've always got the opportunity to say, "Look, I'm not up to it. I'm not feeling well." And there's a really strong sense in the legal fraternity of life, health, and balance, and all that kind of positive thinking about keeping people in good health. And if I would have thought that if any practitioner got to court and was feeling under the weather, they would be well within their rights to say to the court, and the court would encourage them to do it. To let them know and seek an adjournment, albeit one day or however long it would be. So I think that the answer must be that if you are going to proceed in under a guise of illness, you're only going to have yourself to blame later on, because the court will grant you the opportunity to stand down sick for a brief period.
Yeah. And I guess are closing submissions almost, they're like the grand final of the season. How draining is it in the lead up to this, and just how much effort and energy goes into closing submissions?
I think that they're extremely draining. Some practitioners might not agree with me. When you would be working on a closing for a matter with the amount of evidence that this matter has had and the amount of time that this matter has been going for, and you're trying to link all the dots, and link all the dots in a really cogent way to an extremely intelligent human who's it's not a jury. You know, that's with all due respect to juries. It's not a jury. You're talking to someone who's done plenty of closing submissions before in the past and has been recognised beyond that, such that they're sitting in the position that Justice Hall is. It's, you know, it would be. I would have thought it would be very stressful to be in that position of getting those closings together. I mean, I know even for practitioners who are operating in the lower courts, it's stressful because you don't want to miss anything. You want to make sure that you raise all the things that have happened, and for the prosecution, anticipate what the defence will say and try to nip those things in the bud, and vice versa for the defence. You know, like, I mean, obviously the defence will get to hear the prosecution's closing and can make some notes while that's going on and be able to address those things. But it's a significantly stressful time, especially when a trial's been going this long.
Yeah. And I guess, you know, people have been waiting with bated breath for this trial to resume. It's been 4 weeks. Is a day delay or another couple of days delay, is that problematic in any way, do you think? Can you foresee how this would, upset either side?
No, I don't think it's problematic in any way, shape or form in the terms of the structure and the management of the trial. It's problematic because of the cost. But there's nothing you can do about that. I mean, I think that, especially given the current health status around the world, I mean, we're hearing now that the status moving forward for everybody is going to be, if you feel sick, don't soldier on, stay home. So, it'd fly in the face of all of those new motives, if we could put it that way, that someone would go to court and present a closing on a matter this significant if they weren't feeling up to it.
Yeah. Tim and I were just chatting in the last podcast and saying how, you know, it is actually quite extraordinary that the trial got to the point at which it is right now anyway. Tim, how had court prepared for the return today? They were expecting, I imagine, some crowds.
Yes, they were, Nat, and some crowds have actually turned up at 8:30 ready to take their position in the court, and then they were sort of politely but firmly told by the security, well, it's not going ahead today. So that was an inconvenience for them, obviously. Other measures have been put in place, so the live streaming into another courtroom away from the actual courtroom had also been arranged, specifically for that reason, that they were anticipating more people that had to turn up today than had maybe before we had the break. They've obviously put social distancing measures in place in court, which will obviously still stand, whether it be tomorrow or later on in the week when we do get underway. So significant sort of efforts had been made by the court, ready for the resumption today, quite sensibly, obviously. So every measure has been put in place to make sure it goes ahead. But when, as we think, one of the main players in court is not feeling well in the current climate, obviously there was going to be no issue with getting that temporary adjournment. But as I say, we just hope it's not anything more serious than a mild cold or something like that, and we can all carry on regardless, whether it be tomorrow or in the coming days.
Did you happen to get to talk to any of the members of the public who had turned up, or any of the victims' families? Because as we have talked about, this was quite a significant day for the Rimmer family.
Yeah. Yes, I did. And there was some frustration, natural frustration, if someone makes the commitment to come into court and then it doesn't happen. Obviously, that's gonna put your plans to one side. I have spoken to someone that's been sort of helping the Rimmers through the trial this morning as well, and as we mentioned on our podcast over the weekend, today is a significant day, and tomorrow is a significant day for them because it's the 24th anniversary of Jenny's disappearance. So this day was always going to be difficult for them on a couple of levels, and that person told me that it didn't make it any easier for them today that court didn't go ahead, but at least they didn't make the trip. I understand that they were given enough warning to say, look, it might not go ahead this morning, so you might not want to jump in the car or jump on the train. And so, yeah, it's annoying, I suppose, frustrating for everyone, because having had a trial go for this long and to be this close to the end, for it to be delayed, it's a speed bump, but as I said, hopefully not a big one.
Yeah, I mean, it's good to hear that some of those people did get the heads up, possibly.
Mm-hmm.
We've just got a couple of questions that we might answer before we head off. So this is from Trent Green, and he says, given the prosecution is no longer pursuing the emotional upset argument, is it actually required to identify a motive for the offence to the court? And what is the answer to this question used for, and how does it go towards potential sentencing, etc.?
Oh, boy.
Bit to unpack there.
Well, the starting point, I think, has to be, which you say time and time again, the prosecution have to prove beyond a reasonable doubt that whatever they're alleging has taken place in the format that they say it's taken place. And there's a few things in there which we refer to in the legal world as elements. And I'm not going to go into what the elements are, but motive isn't one of them. So it's not a case where, well, my understanding is it's not a case that the prosecution needs to show a motive, but the way that a motive would play out in any court case is that it creates an inference. It creates something that would lend itself to supporting the prosecution's theory. So in the case that the prosecution may have let go of the emotional argument, as that listener asks, it's still the prosecution's case. Well, I imagine it will be. There's still the prosecution's case that the accused person did all these things that they're alleging that he did, and they don't necessarily need to address why he did it. I mean, it's helpful if they can, but if they can't, it's not the end of the world. I mean, sometimes you might just never know why someone did what they did. And I think the last part of that question, Nat, was what impact does it have on someone down the track during the court process, i.e. sentencing?
Yeah.
I think that there are some, I do come across circumstances where I think, this is actually quite a relevant thing for sentencing, where someone might actually be guilty of something, and this is not in any way related to the Claremont case, it's in any legal matter, that somebody might actually be guilty of something, but they've got something that really has an impact on what their sentence might be. So, it's the mitigating factor. And I think that might be what the listener's alluding to. But in terms of what the motive might have been, if you think about this case, I mean, it's hard to imagine that we will get any insight into that. Let's say the accused person is convicted. Well, I don't necessarily, or history wouldn't suggest that a person who gets convicted is going to all of a sudden turn around and say, yes, I agree, I actually did this, and this is the reasons why I did this. And if he's acquitted, well, the same applies. I mean, I just don't know that there's ever going to be anything. I mean, there'll be things put forward in mitigation, but I don't know that they'll address specific things like motive. I mean, stranger things have happened, but it seems to me, if you just thought logically about it, what could be said in mitigation for anyone who was convicted in this scenario is limited pretty much to their personal circumstances and what their other surrounding things, rather than the elements of the case. I mean, I've been in sentencings before where I've thought to myself, gee, what is it that we could say about this person? And, after they've been convicted at a trial, what is it you can say? I mean, there is always things you can say, but it is a bit of a, it's a bit of a tricky situation, because if they plead not guilty and then they've been convicted at a trial, I mean, it's a bit of a sticky sentencing environment, isn't it?
Yeah. We also have a question from Danielle, which I'm not sure that we can answer at this stage either, Danielle, but she asks, do you know if the verdict will be televised like the Pell case, as the case is so high profile and has national interest?
Yeah, well, that's a question that I understand is being tossed around at the very highest level of WA legal circles right now. I think There are some within the legal fraternity very high up that would like it to be live streamed at the very least via the court website because of several reasons. Obviously, the public interest, the public purse has shelled out a lot of money for this trial to be staged, and going to social distancing and the likely attendance in court on the day of that verdict will be huge. I think some feeling is that if it were to be live streamed, then that might help the management of the public and the traffic that might be through the court. But then on the other hand, there are logistical things that would have to be put in place and very relevant legal principles that would have to be thought about as well. Most notably, I suppose, the witnesses who have had their identities suppressed over the whole series of pre-trial hearings and the trial itself. If there were to be an inadvertent slip by one of the parties addressing the court and one of those names happened to be mentioned and it was being live streamed, then that would cause a lot of issues, obviously. So there's big things to be weighed up, but I'm certain that it is being considered that might occur on the day of the verdict. There's another level to that, I suppose, in that whether broadcasters and media will be allowed a camera into the court to record the proceedings, but not necessarily broadcast them live. That's another consideration. There's obviously the audio transcript of the court that is being placed on the Supreme Court website, but that is having some delay put on it as well. So, yeah, a lot of balls in the air there, and I'm sure that we will get some more clarity around that, hopefully well in advance of the verdict, so we can all make the necessary arrangements to get ready for that day of the verdict.
Yeah, you can see why live could be potentially problematic, whereas pre-recording would allow for any, slip-ups that can be taken out. But if you think back to the kinds of crowds that we have seen at very high-profile verdicts, you're talking massive scrums of people.
Yeah, but my understanding is that certainly WA police are very well aware of what the interest might be on the day of the verdict when Justice Hall's verdict is handed down, and so they are going to place some significant arrangements around that in terms of ingress and egress of court for the general public, for the media, for the families, most notably probably after the verdict, because that is when you are trying to get close to all those parties to try and see if they want to say anything, and that can cause its own issues because there are rules around what you're allowed to do on the court environs. That means that a lot of the time you're on a public footpath, which can cause its own issues. And one significant trial that we've touched on during the podcast, the Lloyd Rainey murder trial, I did cover that verdict on that day, and it did descend, I've got to say, into a bit of a free for all on the front courts of the steps, which is not. It's not really beneficial for anyone, particularly those that are very close to victims. But the general public, it caused a lot of problems. I think the WA police have that in their mind, that particular trial in their mind, and they know this is going to be as big, probably a lot bigger than that in terms of just an event that the WA justice system will have to try and manage as best they can.
Absolutely. Now, you mentioned the audio recordings, and we've had a couple of questions from you out there about not being able to access or being unable to find the audio recordings. So Kate Ryan, our producer, has given a very clear rundown of how you can find it. So basically, as of today, you can still access the audio from the court. You go onto the Supreme Court of Western Australia website, go onto the main page, and there will be a link there which says State of WA versus Bradley Robert Edwards audio, and that audio recording is right there. And then what you need to do, you would need to enter your email address, and then you have to agree to the terms and conditions, and then the court will email you a link, and part of that is you cannot record, copy or send that audio anywhere else. So that's basically how it works, and it is available and there right now. Well, thank you both very much for your time, and fingers crossed that whoever is feeling unwell is feeling better for tomorrow. And Tim and Alison and myself will be back tomorrow with day 86 of Claremont in Conversation, and we look forward to joining you then.
This podcast is hosted by Natalie Bongiolo, produced by Kate Ryan, and recorded in the studios of 7 West Media. Sign up for daily emails and all the latest on the Claremont trial at thewest.com.au. And if local news delivered differently appeals to you, tune into WA's newest morning show, The West Live with Jenna Clarke. It's talkback radio, but without the interruptions. Listen live weekdays from 8:45 a.m. on thewest.com.au or catch up with the podcast.